Hi guys, my name is Maya, and this is my presentation on criminal competencies. Topic 2, competence to exercise the right to remain silent. So let's start by talking about competency. What is competency? So this quote I pulled straight from Melton, and it says, much of Western society has subscribed to the principle that human dignity demands respect for individual autonomy unless compelling reasons to infringe upon that autonomy exist. Essentially, this means that the state should not invoke the power to make decisions on an individual's behalf unless that individual lacks capacity to do so themselves. And at that point, there would need to be proof that the individual lacks the capacity to do so themselves. So let's go right into it. Competence to exercise the right to remain silent. Is this person competent to confess? Do they understand their rights? Do they understand the criminal proceedings and what this confession might mean for their future? So, when would this kind of competency be evaluated? The competence to exercise the right to remain silent is typically evaluated prior to a suppression hearing. What is a suppression hearing? It's the pretrial hearing where the judge decides whether evidence brought forth by the prosecution is admissible or not. So at this point, during a suppression hearing, the prosecution is going to present the judge with all the evidence that they plan to present the court with during the trial. And at this point, when the judge is deciding whether or not the evidence is admissible, he's also going to be looking into um, the competency, and then he is going to make that decision. Was this person competent to essentially make the confession that they did? So that's all going to be decided by a judge during a suppression hearing. When arguing this specific incompetence, the defense typically is going to argue that at the time of the interrogation or when the so called self incriminating statement was made, the defendant was incompetent to waive their Fifth and Sixth Amendment rights. This essentially might mean that maybe the person just didn't understand their Fifth and Sixth Amendment rights. Um, Maybe they weren't read their Miranda rights. Maybe they didn't fully comprehend the extent of the situation or the criminal proceedings. So, by arguing this point, the defense is going to make the motion that the defendant's statements should be excluded from the hearing. And that is going to be, again, decided by the judge during that suppression hearing, whether it will be excluded or if it will be admissible in court. So, what's the next step? After competence is questioned, where do we go from there? As with any competency evaluation, the mental health professional will be brought in to evaluate the defendant. However, in order to do so, the evaluator must really understand the law of confessions and to know what they're looking for. So, what is the law of confessions and how does it take effect? If a confession is made, it will be put in front of the judge during a suppression hearing. And at this time, the judge is going to really look into the voluntariness of said confession. So the law of confessions essentially states that if a confession was coerced out of the defendant, or if police interrogation tactics are deemed immoral, then said confession is not admissible in court. So by immoral interrogation tactics, we're talking about how long was the interrogation? Was this person interrogated for, 6 hours straight with no breaks, with no counsel? Was this person were they interrogated like in a timely manner? Were the police using tactics such as maybe fear to get a confession out of this person? Anything like that, if it's proven, that confession is not going to be found admissible in court and it will be dismissed. So, what is voluntariness and how is it determined? Now, I pulled these 5 standards from the Cornell Law School website because they really seem to accurately kind of describe what exactly a judge is going to be looking for when considering the voluntariness of a confession. So, a judge will determine the voluntariness of the confession after considering these 5 standards. Number one, the time elapsed between arrest and arraignment. Essentially, making sure that the confession was made after arrest, but before arraignment. And additionally, the delays between arrest and arraignment could suggest a violation of constitutional rights. It could also suggest that the confession was made under duress. Number two, whether the defendant knew the nature of the offense of which he was suspected at the time of making a confession. So, if this checks out, essentially it would demonstrate the defendant's rational intellect and understanding of criminal proceedings. So, if a person is confessing and they don't entirely know the nature of that offense, it might express that they don't really understand the full proceedings. They might not know what the consequences of said confession might lead to. They might not know what the next step is. Um, Now, by confirming that the defendant did know the nature of the offense, it kind of reduces the risk of police coercion or persuasion, and it also satisfies due process laws by ensuring that the defendants understand the crime and the proceedings. Number three, whether or not such defendant was advised or knew that he was not required to make any statement and that any such statement can be used against him. Proper advisement is crucial in protecting a defendant's Fifth and Sixth Amendment rights. So, this essentially means, was this person read their rights? Do they know that they don't have to make any statements? And this ties into number four, whether or not such defendant has been advised prior to questioning of his right to the assistance of counsel. So, does this person know that even if maybe they can't afford a lawyer, or maybe if they've never had contact with one, they're not sure what the next steps they should take are, they will be appointed counsel. They will be given public defense if they so choose it. So this kind of satisfies the due process laws. And then number five, whether or not such defendant was without the assistance of counsel when questioned and when giving the confession. So by making sure of this, it satisfies the due process laws again, and then absence of counsel just leaves more room for police coercion. So this case, we're going to tie in Brown versus Mississippi, 1936. This is brought in through Melton. It's talked about in the book. So in 1936, three black men were convicted of murder of one white man. Their confessions were extorted by police officers who physically tortured and beat them. They were whipped, they were hanged, they were essentially just tortured and beat until they eventually confessed. And one man was told that if he confessed, the whippings that he was continually receiving would finally stop. And then the Supreme Court conferred that due to the nature of the confession and the brutality that they faced, the defendant's confessions were inadmissible in court. So So this is another case that was brought in by Melton that I just wanted to talk about really quickly. And it's Colorado versus Connolly. So Connolly was a man who experienced what he believed to be command delusions, and he stated that these command delusions compelled him to confess to a crime to the police. Connolly was read his Miranda rights and informed that he did not need to speak of the offense that he was accused of. The defendant insisted on confessing, and he provided police with details of the murder that he was being charged with. Now, during this confession, the police were unaware that that the accused had a history of mental illness, and they didn't perceive any of his behavior to be a result of mental illness at all. They just thought this was a man who needed to come in, and he, for whatever reason, felt a need to confess to a murder. So the defense presented evidence arguing that the defendant's impairment was a direct result of mental illness. And the evidence that they brought forth included a history of psychiatric hospitalizations and medication noncompliance for approximately 6 months. So, in the years leading up to his confession, Connolly did have a history of extensive psychiatric hospitalizations, and he also wasn't taking the medications that he was prescribed for about 6 months. So that kind of medication noncompliance is going to reverse a lot of the effects of those medications. And so that is probably what brought on these command delusions, as he called them. And so, what was a result of this? The defendant's confession was ruled admissible because there was no implication of governmental coercion. He was found competent to exercise his right to remain silent, and he was then charged with the murder. So, the last thing that I want to talk about really quickly is the possibility that a confession can be false does not render it inadmissible. So, that is my presentation on the competency to exercise the right to remain silent. Thank you, and I appreciate your time.